G'day everyone and welcome to Key Knowledge dot point number 4 of Unit 3 Area of Study 1. Our quote for today from William Longgood: dreams and dedication are a powerful combination. This is again vitally important for where or whatever stage of life you're at, but particularly with your Year 12 VCE, about making sure you do have maybe not so much dreams. There's still a long way to go in terms of where you want to go and what you want to do and that sort of thing. But at least be starting to think about what goals you can set, and then combining that with dedication is a powerful combination. I know I've been really poor at goal setting in my life, and it's something that I've really tried to embrace in the last few years, and I've found it really beneficial. So it's something that's always a work in progress, and you're never going to be perfect at, but that doesn't mean you have to try it once and give up. So have a crack at setting yourself some goals, combine that with some dedication, and we're going to get some great results. So as I said a moment ago, we are up to Key Knowledge point 4. This follows on directly from Key Knowledge point 3, which was the rights of an accused person. Now we are switching to the rights of victims. Again, this works out exactly the same as the rights of the accused. It says to us we need to know, the rights of victims, general statement, but then also includes 3 specific things: the right to give evidence as a vulnerable witness, the right to be informed about the proceedings, and the right to be informed of the likely release date of the accused. So 3 specific ones that because they are listed in the study design, we could be asked a direct question about. Again, it is the exact same key skill as last one. We are just going to, at the end of this, need to be able to explain them. Nothing more in depth, no pros and cons. So explain the rights of the accused, which we've done, and of victims in the criminal justice system. Our essential question, therefore, is: what rights does a victim have during criminal proceedings? Again, when we get to the end, I'll say it again. But here we're looking at, when you answer this essential question at the end, I don't want you just listing saying, you have the right to give evidence to vulnerable witness, 1, 2, 3. I want you to be able to actually explain them and show that you understand them in a paragraph. And if not, obviously, then you need to do the extra work. Also, before we just kick into the content, hopefully at this point you're already starting to see where this unit is, or this area of study particularly, is heading, particularly with that final key skill. So the looking at real or hypothetical case scenarios. I'm sure you can start imagining in your head, a question where it's going to give you maybe a couple of paragraphs of text about some form of legal situation. You can imagine it's a woman who's been charged with some offence and she's in this court, and this thing happens during the trial, and then she's eventually sentenced. And then it's going to follow on from that with a bunch of questions about, hey, why was this witness able to give evidence in this way? Which will enable you to say, one of the rights victims have is this. A follow-on question from that be, what is one right an accused person has in this scenario? And you can talk about fair trial. It might ask you whether it's a summary or an indictable offence, and it will then go into questions about sentencing and so on that we cover later on. So that's the sort of thing we're trying to gear ourselves towards, is being able to get, say, a 2-3 paragraph scenario and then answer a range of questions from this entire area of study about it. So apply this learning. So that's where you need to start, as much as possible, actually engaging in a little bit of reading, whether it's news websites or actually physical newspapers, if that's something your family has access to or gets. And just starting to try and find some legal articles and engage a little bit and be like, okay, I'm reading through there. I see that mentioned. I know that means this is an indictable offence, and there'll be a jury. Just really starting to use the language and having those conversations. So, what are the rights of a victim? Well, What we'll look at in a moment is the fact that Victoria has a victims charter, and it's a lot more extensive than just these clear three. But again, the study design is only asking us to know three, so we're not going to go over the top. Our three rights of the victim in criminal proceedings that we need to know are: 1, the right to give evidence as a vulnerable witness; 2, the right to be informed about the proceedings; and 3, the right to be informed of the likely release date of the offender. As I said, these are covered in a victims charter, which I'll touch on where you can find that in a moment. Where we talk about evidence as a vulnerable witness, this is the idea, and I'll go into more detail about the fact that because our legal system, and hopefully if you've done year 11, you remember this is very adversarial in nature. Questioning is very direct. It's also potentially likely that an accused person may represent themselves. It can be really traumatic, particularly for a victim of a violent crime or most notably a sexual offence, to actually have to sit, mere meters away from that person who's caused them harm. I'm sure you can think of someone in your school who has caused you some form of harm over the past 5 or 6 years, pissed you off in some way, be it a relationship breakdown, a fight back in year 7 or similar, and you've probably had the feeling that you don't want to be in the same room as them, you don't want to be around them. Imagine that if you're actually someone who's been a victim of a really serious crime, and the only way that it's possible for them to go to prison is for you to go into a room with them and sit within 5 meters of them. That is terrifying. So there we have the right to give evidence as a vulnerable witness, and that's the reason why. The next right of a victim is the right to be informed about the proceedings. Basically, legally mandated, the police must tell you what's going on if you are a victim of a crime, or you're a victim of an alleged crime. As they investigate it, they have to update you. Once they go to court, if they charge someone, they have to update you. They have to tell you when things are going on. Finally, if you are a victim of crime and someone is convicted, and in this case sent to jail, you must be told when they're going to be released. That means if they get parole, which is early release based on good behaviour, you have to be told, basically allowing you to prepare for the fact that you might see them in the community. I teach in Horsham. I mean, it's not as small a town as there could be. It's 17,000 people. But it's small enough that if you were the victim of a crime, and you didn't know when the person who had caused this harm to you was being released, that you could well and truly expect to potentially run into them all of a sudden in Coles or Woolworths. I mean, there's, Coles, Woolworths and Aldi, one of each in town. So it's about making sure that those situations are avoided and people and victims are able to prepare for that. As I just touched on, each of these and basically some more information about what rights victims have can be found in the Victorian Victims Charter. I've put a link to it here. If you just search for Victims Charter, this will be probably the first link that comes up, or Victorian Victims Charter, I should say. And it's from the OPP's website, so the Office of Public Prosecutions. So they're obviously the ones who are taking accused people to court, so they're the ones that have the information about what victims can get. Our Victorian Victims Charter is modelled pretty much directly off the Victims Charter that comes from the mouthful United Nations Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power. And that one is linked there. If you write all of that in, and go to the UN website, you'll find a copy of that to have a look at if you'd like to for some further reading. So, in a bit more detail, evidence as a vulnerable witness. So as I just stated, you can probably think of a situation that's been quite traumatic for you, where someone has potentially harmed you in the school setting in the last 5 years or even earlier, be it a bullying situation, a fight, a breakup, that sort of thing. You can imagine the idea of all of a sudden having to, sit within 5 meters of them and explain what happened, potentially with them questioning you directly. So the sorts of things that we can do to make that a more comfortable process for a victim include what's in this image here, which is you give your evidence in another room via closed circuit television, so CCTV. You can see on a TV exactly what's happening in the courtroom, and this woman will be asking questions. And then you in the corner obviously see what you look like. Potentially a little bit like my little head in the corner at the moment. As well as that, it could mean you're actually in the courtroom in the normal witness dock, but you have a friend or relative with you. They don't say anything. They're not allowed to answer any questions or interrupt or help you, but they're just there, that physical presence. You can have a screen erected around you so you don't have to see the accused person. You give your evidence from behind it. A bit of an interesting one. I think they generally go with the CCTV these days is over that one. A little bit like the sort of screens you see at horse racing events, almost, in a sense. It's a bit weird, and obviously technology allows them to do the same thing, but actually physically remove you from the space now. So that's much more common. Essentially, the one thing you can't stop happening is the idea that witnesses need to be able to be questioned by both parties. So one of the core ways we ensure that an accused person gets a fair trial is that all evidence is tested. The rules of evidence are applied equally to both parties. So that means that if I'm giving evidence about a situation that occurred between me and you, obviously my legal team, the prosecution in this case, if I'm the victim, get to ask me questions so I can tell that story and respond to their questions. And then you get the opportunity to basically ask me questions that potentially refute that, cast doubt on it, etc. And that's what we call testing the evidence. Hopefully showing to a jury for an accused person that perhaps it's not as reliable as the prosecution makes it out to be. The purpose of that, therefore, meaning that the jury can assess whether the evidence is reliable and therefore decide whether they can convict you beyond reasonable doubt or not. One example of this, just to put it fresh in your mind, hopefully, I took a class down to the county court a couple of years ago, and we saw a trial there where a man from Frankston had been charged with basically he'd contacted this woman on Facebook and told her that he would slit her throat, and then he'd sent her images of people with slit throats and superimposed her head onto the bodies. Obviously she was terrified, had never met this man, so when it came to her giving evidence about receiving those messages, which there was screenshot documentation of, but she still had to answer questions about that. She did it from a similar setup to this, so CCTV from a different room, and he actually represented himself. So he then directly asked her questions, which led to quite some tense exchanges in the courtroom where she got quite emotional. There are a lot of tears from her position outside of the courtroom. But ultimately it meant he was able to adequately question her about the exchange. At the end of the day, the prosecution might apply to the judge to have the evidence, have the victim give evidence as a vulnerable witness, but the judge is the one who ultimately decides whether to grant permission or not. Why is that? That's because the judge is in charge of the trial. The judge is in charge of ensuring that it is fair, ensuring that it is dealt with in an impartial manner. So therefore, they're in charge of deciding whether a victim can give evidence as a vulnerable witness or not. Then we have informed of the proceedings. So what the letter of the law actually says is that you must be, if you are a victim of crime or an alleged victim of crime, you must be informed at reasonable intervals. Now, it's never stipulated what that is, that's open to interpretation, but the idea being that you need to just generally be kept up to date with what's happening, provided that that will not jeopardize an investigation. If at the conclusion of the investigation a charge is filed, you need to be informed about from then on if there's any changes to that, if that's modified at all, when the court hearings are, so you can attend if you would like, and then you need to be informed of the outcome at the end. And that's often done in writing. If there is no charge filed, perhaps they can't get enough evidence, it needs to be explained to you why they didn't file that charge. One that is in the news right now, and maybe when you're watching this it won't be anymore, but Australian actor Craig McLachlan, it's come out in the last few days, has been accused of sexual harassment by both female and male cast members of the stage show of the Rocky Horror Show. They've made those complaints to the police, first and foremost, before the media released their information. And the police are investigating those claims, which basically means they're asking questions and they're finding out if there's any evidence beyond, word of mouth, are there other witnesses, so on and so forth. If ultimately the police in that situation decide not to file charges against Craig McLachlan, not to charge him with sexual harassment, they would have to then sit down with these victims and explain to them why. And this rests with the OPP or the police prosecutor, so either the police or basically society's lawyers to do that. Finally, we have if the accused is found guilty, so they are an offender. That could almost be changed to offender, because if they're in jail, they have been found guilty. You as a victim have the right to be told of their likely release date. What you have to do here is, if once they're found guilty, you have to apply or put your name down to go on what's called the Victims Register. This basically, from my understanding, online database, which allows you to basically log on and they'll send you updates on how long the person is going to be in prison for. You'll get notified if they apply for parole, so if they apply to be released early, if it's granted, you'll obviously they'll let you know that it's granted, and any conditions that are applied to that, be they curfews, restrictions of movement. So often, like, people can be released on parole, but they have a curfew, so they have to be home in these hours. They have to check into a police station once a week, or perhaps they're not allowed to go to gambling venues or near schools, that sort of thing. If the offender dies in prison or they escape from prison, you should be informed as well. Probably the escape one important, because they could be coming for you, perhaps. I would hope not. And yeah, if they die, they let you know. In case you wanted to do something with that information. If they do apply for parole, you can make an application to the Adult Parole Board about what effect their release would have. So if you feel like, hey, I'm still pretty traumatised, them coming out into the community that I live in, particularly if it's a small community, is something that I would find really challenging still, and would have a negative effect on me and perhaps my family. You can tell the Adult Parole Board that, which probably ultimately means they're less likely to be released. In terms of skills, it is the same as 3.1.4, so we just need to explain the rights of victims, and specifically potentially those three. So it's the same question as we had for the rights of the accused, but just with victims. So explain the rights of a victim in the Victorian criminal justice system. In your answer, include the right to give evidence as a vulnerable witness, the right to be informed about the proceedings, and the right to be informed of the likely release date. Just before we go to the answer, something that definitely my students have seen, and potentially you have as well, is this isn't a court hierarchy triangle this time. How every question in legal studies will be structured and how the key skills section of the study design is structured is based on what's known as Bloom's taxonomy, which is a fancy jargon for different types of or different levels of thinking. And it works all the way up to analyze and then evaluate at the top. So what we have with an explain question is just a question that is quite low. It's lower order thinking. It's just basically relisting information. So what I'll often talk about in these videos is if it's an explain question, if you want to get the full 3 marks here, all you need to do is show understanding. So I want to read it. It's really vague. It's not like, hey, you need to use these specific words. There's not an exact formula like maths. But I need to read your answer, and when I read your section on the right to give evidence as a vulnerable witness, I need to finish that, and I need to know that you fully understand that, okay? That it's not a copied answer perhaps, that it's not, there's not a couple of words out of place where you're like, I think this is right, but I don't quite get it. I need to read it and be like, you understand that, and then I can give you a mark. And that's what we talk about, and that's the language I'll often use. So if we look at a sample answer here, just a little starting stem to get you going, what I'm trying to show the examiner here is that I understand the concepts. So really important is these setup words or linking words. So firstly, victims of crime have the right to give evidence as a vulnerable witness. This involves witnesses being able to have support in the courtroom or giving evidence by video link from a secure location. Okay, finish that and you're like, yeah, he understands that. Yeah, he understands what giving evidence as a vulnerable witness means. Victims also have the right to be informed about proceedings, meaning they should be updated regularly on the process of an investigation or dispute. Again, yeah, he understands that. They've got to be updated regularly on the progress of the investigation. Done. Finally, so another little linking word, victims have the right to be informed of the likely release date. Victims who are placed on the victims register, okay, good use of legal vocab, are able to receive information about the length of sentence when an offender has applied for parole and their ultimate release date. Okay, a little bit of extra information, listed a few key points there. Again, showing understanding. In terms of its ability to meet the principles of justice, what does it achieve and what doesn't it achieve? Again, recommend pause the video here, have a really critical think about this and think about where you can place different aspects of the rights of victims. And in 3, I will go over to the next slide and show you some of those. So 3, 2, 1. So, giving evidence as a vulnerable witness achieves fairness because it's done in a way that still allows evidence to be tested. So if we didn't have these processes, there's a chance that the evidence wouldn't be given at all, or you would hate to see a system where we looked at changing it so that, the defense wasn't able to question a key witness. Like, that would be horribly unfair. So by having evidence as a vulnerable witness, we allow that evidence to still be tested, which supports the victim. However, it's a really good linking word to remember for when we eventually evaluate. However, a vulnerable witness may make the jury more likely to believe the accused is guilty, therefore removing impartiality or adding bias. Okay, and we know impartiality is the key to fairness. If someone is giving evidence by CCTV from another room, or lo and behold, like we said, could happen if someone is giving evidence with a screen erected around them, if I'm sitting there on a jury, it's going to go through my head. It's like, this person can't even come into the room, the same room as this person, or can't even look at them. Clearly, this thing must have happened. Okay, I don't even need to hear their evidence. Straight away, I'm like, oh my God, they can't even be in the same room. It has to have happened. Okay, and I'm starting to develop bias towards the accused person. Okay, so that's where giving evidence as a vulnerable witness could be seen as not achieving fairness, because it creates a sense of bias. However, and it's not included, but giving evidence as a vulnerable witness also enables access, because it allows, I suppose, accused or the victim to physically access the courtroom in a way that's not traumatic, and they wouldn't be able to do that otherwise. How is it equal? The rights of victims apply equally to all victims of crime. Doesn't matter what type of crime you're a victim of, you can be on the victims register to find out that information and be updated on the progress. But there is an argument that rights of victims may outweigh the rights of the accused, which therefore means victims and accused people are not considered equal or are not receiving equal treatment. This one here, which we just talked about, the fact that it could create bias if you're giving evidence as a vulnerable witness, is an example of that. Because therefore, the accused person is no longer receiving a fair trial. So in that sense, the rights of the victims are here and the rights of the accused person is here, not equal. Access, being informed about proceedings, again, allows you to know what's going on and access the legal system, both in a physical sense if you want to turn up, but also understanding what's happening. And victim impact statements, which occur in sentencing, allow the victim to be involved in the sentencing process. And we look at victim impact statements in the factors as part of sentencing a little bit later on. Finally, in terms of looking at actual or hypothetical scenarios, I said to you before, we can already start seeing where this area of study is going. You know, we can imagine a scenario and all the different questions that they can pull out of it to ask us. Well, if you want to start doing some reading a little bit further, maybe finding some cases, go on news websites, as I said. I'll include in the notes below, but one thing I mentioned in the first video about the format that these would follow was a podcast by ABC Radio National, or RN, called Law Report, little half-hour one, and they did an episode, it's probably about 7 or 8 episodes back, called The Complexities of Sentencing, and the link directly to it there. This includes a short section where the wife of, I'm sure you've heard of Blue Ribbon Day, there's a couple of footy matches played for the Blue Ribbon Cup, and people, you buy the little blue ribbon bears to help talk about or remember the death of police who were serving the state of Victoria, and that was all set up following the death of Sergeant Rodney Miller and Roger Silk. I might have the first name wrong there on Silk. But anyway, this podcast episode features the wife of Rodney Miller, and she talks about at the time when the criminal trial was occurring, how she perhaps felt that victims weren't really looked after as well as they could have been, and how she would have been like to have been looked after more, but how her views have sort of changed. So you get a little bit of an idea, and it's good pre-reading or pre-listening before we get to sentencing. The other one to look at is just literally the Victorian Government's Victims of Crime website. So it's a website dedicated to victims of crime, or for victims of crime. It has basically tab sections on, what to do if you think you're a victim of crime, followed by what happens during an investigation, what happens at court, what happens after court. So you can actually just tick down those boxes or those menus and basically gather some more information about how victims are helped and what rights they have in our criminal justice system. As always, close with our essential question. As I said at the start and in the last video, don't just answer this question as, the rights the victims have are they can give evidence as a vulnerable witness, they can be informed about the proceedings, and they'll find out your release date. Done. Full stop. No, when you answer this, it's those 2 words that will come up often. You want to make sure you show understanding. If that means writing a paragraph, that means writing a paragraph. If you don't think you can write in that detail about it, that you need more information, as I said, rewatch, pause, slow down, etc. Textbook, talk to your teacher. Again, if you've got any further questions, feel free to ask them and leave reviews and that sort of thing. And yeah, jump into 3.1.5 when you're ready to go.